Telstra Corporation Limited v. Commonwealth. Background to the case. From the 1880s, Australia had developed an extensive public switched telephone network (PSTN) copper infrastructure, which is widely dispersed throughout the country and immediately evident in most business and residential premises as the standard telephone network. This infrastructure is distributed nationwide by telephone exchanges, from which it locally extends into customer premises. The physical copper connection between the customer premises and the telephone exchange is known as a local loop. There are about 10.1 million local loops and about 5,120 local exchanges. Local loops can carry services in two ways, unconditioned and shared. Unconditioned local loop services are unconditioned in that the electrical properties of the loop are not altered by any physically connected equipment. Local sharing services (LSS) are unconditioned local loops where one carrier uses the lower frequencies range of the line, known as the voiceband used in regular telephony, whilst that same carrier or another uses the higher frequency range of that same line for high-speed services such as ADSL Internet. Prior to Federation, the PSTN infrastructure that then existed, the Constitution provided for the transfer of the network to the Commonwealth of Australia, who operated the network through the Postmaster General's Department. In July 1975, the assets constituting the PSTN were transferred to a body then called the Australian Telecommunications Commission, later changed to the Australian Telecommunications Corporation, created under the Telecommunications Act 1975 and began trading as a monopoly under the name Telecom Australia. In a parliamentary move to invite competition, Telstra Corporation Limited, then known as the Australian and Overseas Telecommunications Corporation, was incorporated under the Corporations Law of ACT in November 1991 as a company limited by shares, the sole shareholder being the Australian Commonwealth. The PSTN was then vested in Telstra as of 1 February 1992, in accordance with the Telecommunications Act 1991, of which one of the stated objects is creating a regulatory environment for the supply of telecommunications services which promotes competition and once privatized, Telstra operation became subject to the Trade Practices Act 1974, which requires that competitors be given access to the PSTN and related services, and empowered the Australian Competition and Consumer Commission Act. It was this enforced pricing model that Telstra rejected, claiming they are forced to provide wholesale access to competitors at below-cost price, which they believed amounted to an acquisition of property other than on just terms contrary. Thus, Telstra began proceedings in the High Court of Australia against the Commonwealth. The 11 competitors involved were Internet Service Providers Primus Telecommunications, Optus Networks, Chime Communications, Zized, Powertel Limited, Request Broadband, NEC Australia, Macquarie Telecom, Ancom, Adam Internet, and Agile. The Telecommunications Access Regime. The PSTN was vested in Telstra, with effect from 1 February 1992, under the Telecommunications Act 1991, which commenced on 1 July 1991. This meant that all of its provisions had commenced prior to the PSTN actually being vested in Telstra. This legislation limited a former monopoly control over the telecommunications industry by promoting the fair competition subject to the Australian Telecommunications Access Regime set out in Part XIC of. This regime applies to telecommunications services which, following a public inquiry, are declared by the Act as declared services. Section 152L3 of the TPA provides for the declaration of these services subject to Part XIC. Once a service becomes a declared service, the service provider that provides that service must then adhere to the standard access obligations as described in Section 152AR. Part XIC of the Trade Practices Act was inserted in that Act by the Trade Practices Amendment Telecommunications Act 1997. Argument. Telstra rejected the regulation of ALS and LSS under Part XIC of the Trade Practices Act alleging that the wholesale access price caps imposed on it by the Act do not allow it to recover the operating costs of the actual service being accessed and retailed by a competitor, alleging that this amounted to a compulsory acquisition of Telstra property by the Commonwealth. Section 51(c) of the Constitution states that the Parliament has legislative power to create laws relating to the acquisition of property on just terms from any state or person for any purpose in respect of which the Parliament has power. Impugned provisions. The argument made on Telstra's behalf focused directly on sections 152L3 and 152AR of the Trade Practices Act and asked whether these two sections, in their applications to ULL and LSS, were beyond the legislative powers of Parliament by way of Section 51(c). Therefore, rejecting the validity of sections 152L3 and 152AR, which it claimed effect an unconstitutional acquisition of Telstra property by the Commonwealth on unjust terms. As mentioned earlier, these two sections provide for the declaration of services by the Act and impose standard access obligations. If then, as Telstra continued to argue, terms and conditions may be fixed for its compliance with standard access obligations in respect to local loops, all and LSS, which are terms that differ from those that would be fixed in arm's length, all parties being independent, and equal bargaining between it and the access seeker, the provisions that lead to that result provide for an acquisition. Section 152EB. Acquisition of property. In Australian courts, Section 51(c) of the Constitution focuses on matters of substance rather than form, and therefore the definitions of acquisition and property are to be interpreted liberally. In the case of Yanner v. Eaton, it was mentioned that the word property is often used to refer to something that belongs to another. Though in law, property does not refer to a thing, it is a description of a legal relationship with a thing. It refers to a degree of power that is recognized in law as power permissibly exercised over the thing. The concept of property may be elusive. Usually it is treated as a bundle of rights. In this same case, it was also accepted that an extensive frame of reference is created by the notion that property consists primarily in control over access. Much of our false thinking about property stems from the residual perception that property is itself a thing or resource rather than a legally endorsed concentration of power over things and resources. Due to these physical acts, Telstra claimed it lost control of and the ability to use the infrastructure which it owned, which sat within Telstra Group property under Rosslam by GM Property and Assets. The competing carriers, listed as defending parties, all connections and disconnections of ULL and LLS are carried out by Telstra regardless of whether those services relate to its own customers or customers of competing carriers. These same defendants pointed to the fact that end users, the customers, can and do choose which service provider connects equipment to the local loops entering their premises, and as long as that choice is not Telstra, then Telstra have no use for that local loop. The defendants' arguments sought to invoke certain elements of the long line of cases in the Australian High Court in which Section 51(c) has been considered. In addressing these arguments, the court decided that rather than begin from the classification of rule and its exceptions, it would instead recognize observations made by Brennan C.J. Toohey, Gaudron, McHugh and Gummo J.J. in Victoria v. the Commonwealth Industrial Relations Act case. It is well established that the guarantee effected by S. 51(c) of the Constitution extends to protect against the acquisition, other than on just terms, of every species of valuable right and interest, including judgment. Consequences. In a media release on its website, dated 8 March 2008, Telstra announced that it accepted the High Court's ruling and stood by its decision to challenge the Act's powers under Section 51(c) of the Constitution, though believes Australia lost an opportunity for further broadband investment when the regulatory regime that rewards competitors. Other commentators believed this outcome to be a clear rebuttal to Telstra's obsession with privatization for its own sake and protection of its remaining monopoly under the direction of CEO at the time Saul Trujillo, a United States telecommunications executive with a history of aggressive litigation towards the U.S. government and its regulators, who was hired by the Telstra board for his ability to had such privileges as those relating to ULL and SSL been upheld, Telstra would be able to charge monopoly-inflated prices for access to its network, thus reducing competition and increasing consumer access fees. Exploitation of such monopoly control would result in increased access costs for competitors, their private and business customers, and eventually all Australian online services. After Trujillo's resignation from Telstra in February 2009, new CEO David Thodey reached out to the Australian government and regulators, such as the ACCC, in an effort to repair the relationships damaged during his predecessor's reign. The taking down of its propaganda website NowWe'reTalking.com, which the company used to criticize regulators and competitors, marked the removal of one of the final vestiges of the Trujillo era. References